If your loved one is detained and they were just denied a bond, you have a few options. Hi, I'm attorney Hillary Walsh, and I've helped lots of people get out of the detention center and fought for thousands of immigrants over the years. So if you are dealing with this situation, I know that this is a very stressful time for you, and I just want to say I'm sorry, but here is hopefully some help and like a path forward for you as you deal with this frustration. So yes, you get ready for this bond hearing, you go in, you hope for the best, you hope that your family member is going to be released from the detention center, and then the judge says no. A lot of times what we do next really depends on why the judge said no. Sometimes it's that the judge wants to see more evidence. Other times it's because the judge says that they don't have jurisdiction. So we have to first determine what was the reason for it before we can know what to do next. But today I want to talk to you about what happens if you want to appeal. First thing that you have to do is at the hearing, the individual needs to say that they reserve appeal, that they want to appeal the judge's decision. Most of the time, the judge does this automatically for people, and it starts the 30-day clock for filing the appeal. Once you file the appeal, then the Board of Immigration Appeals is going to issue a briefing schedule and ask you to explain why it is that the immigration judge was wrong. It's very important that you follow both of these deadlines. First, you have to appeal the immigration judge's denial of bond within 30 days. It cannot be 31 days. It cannot be 30 and a half. It has to be by the 30th day. This is all out of Falls Church, Virginia. And if you need to do a paper filing because your case, perhaps, the case is old and it's not in the electronic system yet, there are vendors who can do a same-day filing for you. So look online for Ben Winograd, and he can take the filing over to the court in Falls Church at the Board of Immigration Appeals for you. So you have to do that by the 30th day. The next deadline that you want to look at is when is your brief due once the Board of Immigration Appeals issues its briefing schedule. So after you say, hey, I want to appeal, it's going to be a little bit of time, usually 2, sometimes 3 months before you hear anything. So yes, your family member is locked up for that time, unfortunately. So we wait for the Board of Immigration Appeals to ask for a brief. They give you a deadline. You have to write your brief and explain why the judge got it wrong in a convincing way to show the Board of Immigration Appeals that you need a new hearing, essentially, and then submit that on time. If you're late with that, again, you risk being able to even do your appeal. Right now, it's December of 2025, and overall, these Board of Immigration Appeals for bond cases are taking usually less than 4 months. That's kind of the time frame right now. So if that's kind of what your family member is prepared to do and prepared to stick it out for, I think an appeal is a really good choice. Sometimes, however, we choose not to appeal, and we instead choose to file for a new bond hearing. We ask the judge to make a new decision. So some of this is strategy, and it's important to work with a really experienced attorney, ideally who knows your family member's judge and knows the court that you're working out of, because each judge is quite particular about what he or she likes to see for bond hearings. I hope this is helpful, and if you need anything else, please reach out to me at New Frontier Immigration Law. I'm attorney Hillary, and I'm here with you every step of the way.